Hello, everybody, and welcome to Getting APIs to Work. Today, I say hello to James Grimmelmann, who is a law professor at Cornell Tech. Hey, James, thanks for joining.
Pleasure to be here.
Thanks so much. The topic that I want to talk about today is the case of Google versus Oracle, API copyright, and so forth. That was decided recently. There was a ruling that came out, and my completely uninformed opinion of that was that in the end, there was no definitive answer, but in most cases, maybe copying APIs can be okay, but it still needs to be decided on a case-by-case basis. I'm sure you have a much better explanation of that. So what was it really about?
This was the long-running case in the United States about Google's use of a modified version of the Java APIs for Android. And the United States Supreme Court said that APIs can, or it wouldn't decide whether APIs can be copyrightable or not. But either way, Google's use of the Java APIs in Android was fair use. So it was legal and not infringing for Google to make that modified version.
And one of the things that I found confusing for being somebody who just works professionally in the API space was that the whole notion of APIs being something different from implementation code is not something that really kind of gets fully reflected in that decision. So I think when I tried to read it, it always sounded like, well, the APIs are kind of part of the code, and it was never like fully clear that maybe these are different things or maybe not. So I'm just wondering, like, if you could explain briefly, are APIs even legally a different thing, or are they not?
That was the argument that Google made in its defense. It argued primarily that APIs are a different kind of thing, not subject to copyright at all. And for whatever reason, the court wasn't willing to take that question on. Perhaps they were too closely divided on it. Perhaps they found an easier way to resolve it, or perhaps they weren't comfortable with their own ability to be clear enough about the opinion they would write. So they compromised and reached the result that what Google was allowed to do was fine, without regard to what the APIs themselves really quite were. Whatever they were, Google's use was fair.
So that's almost an interesting observation there, that from the legal point of view, then APIs are not really a thing, so to speak. They're just part of the code, and what Google did was taking that part, and taking that part was okay.
Yes, that's exactly right. That the court didn't draw a clean or sharp line between an API and an implementation. And it might be that in a different setting, the API could be treated differently or not. And that question stays open.
Okay. So ideally, maybe we would have gotten this clear decision one way or the other. We didn't get that. So I'm just wondering then, for somebody who's worried about copyright issues, let's say, what would you say, how does that decision now change the landscape of, is it okay to copy APIs, even though it's not quite clear what these APIs are, but is it okay to do that, or should I be really, really careful, and that is a big risk that I'm taking?
My takeaway from the opinion is that copying APIs is pretty clearly okay now in two circumstances. One of them is to create something interoperable, and that copying an API for interoperability purposes is exactly what users in general have been invited to do by whoever promulgates the API. And the other is copying an API to create your own implementation of it, or an implementation of something similar to it. And that's very similar to this case. So I think in those two cases, one can generally go ahead, but one might like to be much more careful about internal APIs or things that haven't been held out where the public's been invited to make use of them.
Okay, that's very helpful, I think. Another aspect that I think was reading, but I do have a hard time reading those decisions, I have to admit that, was that there was also an argument saying that by taking the code into a different domain, so to speak, from going from like regular computing to mobile computing, a space where Oracle is not really does not have any footprint, that this was also something that kind of made it easier to say it was okay to do it. Is that really a legal point that was made, or was that just some commentary that I read?
That is part of the opinion. And in a fair use decision like this one, it's a balancing test with lots of factors. So the judges will throw in everything they think points in the direction of the conclusion they reach. I don't know if the opinion really depends upon that. I think you'd get to the same result even if it were in the same domain and not a separate area.
Okay, that's interesting. Okay, James, thanks so much for spending some time. I think you were able to shed some light onto this. Any closing words from you regarding that case and where APIs may be going in the legal space going forward?
I think, at least in the US, it's going to be very interesting to see how other courts interpret this. I think it gives a green light for courts to find a lot of protections for API users and re-implementers. So I wouldn't be surprised if this opinion expands over the next few years as courts use it as a precedent.
Okay, I think that sounds good, at least to me as somebody who works in the API space, and it seems that APIs maybe now have a little less to be afraid of, so to speak, in terms of how legal challenges may come along. James, thanks so much for joining, and I hope that you liked the conversation, and I wish you all the best and see you soon. Bye-bye.
It's been a pleasure. Be well.